Hi, I'm Matthew Ward. I'm the team leader for our Bankruptcy, Restructuring, and Creditors' Rights team at Womble Bond Dickinson. The mantra of today is that we are living in unprecedented times. And while that's true in certain respects, it's also true that our economy has faced many downturns in the past and has emerged. And the bankruptcy regime is here to help companies that are trying to withstand an environment of stress. And our firm's Bankruptcy, Restructuring, and Creditors' Rights team is well equipped to aid clients in reaching a successful outcome at the end of this cycle. We can bring order to what has come to appear as a chaotic world. In a bankruptcy, an automatic stay is put in place. That automatic stay allows companies to reorganize their balance sheet or to sell their assets in a more orderly way than would otherwise be available outside of bankruptcy. Plus, in a bankruptcy process, the buyer of the assets will obtain a court order, which says that the transfer of assets is free and clear of all liabilities. That free and clear order is attractive to buyers, which is one of the reasons why the bankruptcy process actually is often value maximizing and should be considered. Indeed, sometimes it's even necessary for a company to pursue this approach to fulfill its fiduciary duties. In particular, in Delaware, a company's director's fiduciary duties are normally owed to the owners of the company, the shareholders. However, the Delaware courts have held that when a company becomes insolvent, those fiduciary duties are owed to all constituents, including the creditors. At times, the company may maximize value for those creditors through a corporate restructuring or an organized sale process that is available only with the help of implementing the automatic stay. We have represented a number of companies throughout this process and are here to help. Or if you're a company that is interested in purchasing distressed assets, perhaps out of a bankruptcy process, we have represented a number of buyers as well.
We also have represented a number of secured lenders in a broad range of circumstances, all of which involve navigating the balance of being a partner with borrowers, yet having to maximize the return on investments and ensuring that borrowers take necessary measures to fulfill their contractual obligations. This can be a challenging role through a Chapter 11 case, but Womble's attorneys are able to quickly assist lenders in protecting their rights during a restructuring, both in and out of court. Our team also has the ability to work with either borrowers or creditors on modifying and restructuring their credit agreements, including the modification of financial covenants or forbearance agreements to better align with the ever-changing business climate of today. This is a challenging time, not only for distressed businesses, but also for their creditors. Womble's Bankruptcy Group has vast experience in helping creditors deal with both pre- and post-bankruptcy issues. We routinely counsel clients on issues such as monitoring accounts, renegotiating credit terms, and preventing preference exposure. We're working with clients who are dealing with distressed customers. Our team's advice prior to a customer's bankruptcy can be invaluable to help minimize the negative impact once a case is filed. And then, of course, Womble is armed to represent creditors once a bankruptcy is filed, including everything from filing proofs of claim to heavily contested litigation in front of the bankruptcy court.
The Bankruptcy, Restructuring, and Creditors' Rights team at Womble Bond Dickinson has provided a wide spectrum of services to a vast array of sectors, including those that are facing especially difficult times right now. We're very familiar with issues pertinent to retailers and hospitality companies, including reductions in force in compliance with WARN Act and negotiations with landlords and restaurant brand franchisors, and we would welcome the chance to share with you some of our specific successes. We've also represented several clients in the automotive and transportation sectors and are familiar with brokering customer accommodation agreements and dealing with supply chain management problems, including in the just-in-time delivery model that's used by Tier 1 and Tier 2 suppliers to the OEMs. We're also very aware of the toll that the oil price wars have caused to energy companies, from upstream producers to midstream gatherers and downstream servicing, sale, and distribution companies. We've addressed the complex issues of whether a gathering agreement is a covenant that runs with the land. We've helped producers work through hotly contested Chapter 11 proceedings to successful conclusions. We've also helped a number of commercial landlords, both in connection with their tenants' bankruptcies, as well as with their own restructuring efforts.
We have a deep bench of talented lawyers that are able to address pending issues in these trying times, both effectively and efficiently. Whatever the need, we are here to help.